Hello, everybody. We're going to get started now. I'd like to welcome everyone to today's webinar brought to you by the Unemployment Law Project, Northwest Justice Project, and with special guest Tulalip Tribes. My name is Jennifer Yogi, and I'm the Managing Attorney for the Native American Unit at Northwest Justice Project. And I'm also on the board for the Unemployment Law Project. So today our panel is going to be discussing common issues that are coming up around unemployment benefits for Native Americans and tribal employees, and then taking your questions. This webinar was created specifically for the Native community, and in the tradition of the Northwest Native tribes, we'd like to start with a blessing. We are honored to have Natasha Gobin, a member of the Tulalip tribes and a Lushootseed language teacher here to offer a blessing today. Thank you, Natasha.
Slut iwish chash, let us pray. O cha cha shaksiab, ut igwitsi chash twatia slachel, ut igwitsi chash twatibak dosiayus, uwilak itsi chash, guahali chaf ti east abash atibak gua, guahali chaf ti east tiayus altia slachel, ut igwitsi chash twati ad tech de bush. Obasista. Creator, we thank you for this day. We thank you for all of the hard work from the workers who continue to guide us. We ask for special prayers to watch over everyone. Please keep them in good health. Please help everyone find their way during this time of unknown. We thank you for continuing to guide us and for guiding those who are helping us through these hard times. Amen.
Thank you, Natasha.
Thank you, Natasha, very much.
Next slide, please. So here's our roadmap for the webinar. Our panelists will be sharing brief presentations, about 5 to 15 minutes, and they'll be covering general information about unemployment benefits, recent changes in the law, and then they'll talk about some of the common unemployment issues that are arising in their work with Native clients and workers. At the end of the presentations, we're going to move on to your questions. So please put your questions in the Q&A box, and as we're going along, most of the speakers are going to wait until the Q&A portion of the webinar to answer those questions, but feel free to post them as they come up. And we're going to get to as many of those questions as we can. And then just to note that the panelists are going to be providing general information. So if you have a question about your particular case, hang on to that. And we're going to provide information at the end about where you can get help with individual legal questions and claims. Okay, so we have 4 speakers today, and I'm going to introduce them in just a moment, but we'd also like to know a little bit about who is on the call with us today. So if you'd like, please type into the chat box to share your name, where you're calling from, and if you're affiliated with a tribe, that information as well. Our first speaker is Juliana Rep, and she's a member of the Nez Perce tribe and the managing attorney for the Spokane office of the Unemployment Law Project. Juliana has practiced law extensively within the area of civil legal aid and in several tribal court jurisdictions. She serves on national and local boards furthering Native American interests. John Turpak is the executive director of the Unemployment Law Project. Therese Norton is a staff attorney with the Northwest Justice Project's Bellingham Regional Office. She provides advice and legal representation to clients in civil matters. Her clients include low-income Native Americans in Northwest Washington, including tribal members from the Swinomish Indian Community, Upper Skagit, Samish, Sauk-Suiattle, Nooksack, and Lummi Nations. And finally, Desiree Day is an enrolled member of the Klingon-Haida tribes of Alaska, and she has served in the Tulalip tribes for over 24 years. 17 of those years have been dedicated to the human resources field. One of her current assignments is responding to the Employment Security Department on behalf of Tulalip tribal members and government employees. The tribe has offered their Human Resources Department to assist employees with resolving their unemployment claim challenges, and recently included the Tulalip tribal member fishermen who are currently eligible for the PUA claims, and Desiree is going to be sharing more information about that. So welcome to our panelists.
I'll go ahead and start then, Jen. Thank you, Jen, for the introduction, and thank you to Natasha for the opening prayer. Starting a gathering or a meeting, whether it be a tribal council meeting or a general membership meeting or a Washington State Bar Association Indian Law Section meeting or Spokane County Bar Association Indian Law Section meeting. Starting these meetings with prayers is typical for Native people. Spirituality and their culture is inextricably intertwined, and so we always like to start with a prayer to set the tone for a good meeting, that everybody keep an open mind and work together for those that we represent. So thank you for that. I was asked today to give a brief introduction of the origins of unemployment insurance, and then also a little bit of background or discuss the Unemployment Law Project where I am employed. Excuse me. In 1935, President Roosevelt signed the Social Security Act, which contained plans for unemployment insurance, and those subsequently became law. Sorry, let me turn my cell phone off here. The act contained language encouraging states to enact their own unemployment insurance programs. Unemployment insurance was created to limit the difficulties when a person loses his or her job. The unemployment benefits provide funds to individuals who have lost their job through no fault of their own. The unemployment insurance program is funded mostly by taxes paid by employers. There are, I believe, 3 states that require the employees to pay into the unemployment system. At present, I'm not aware of any tribes that fund their own unemployment insurance, but I'm not positive about that. In the United States, all 50 states have their own insurance programs, unemployment insurance programs, and the U.S. Virgin Islands also has such a program. Puerto Rico and the District of Columbia also have their own unemployment insurance programs. The amount of benefits vary with each jurisdiction, and the policies and procedures as to how to apply is left to the state or the U.S. territory to make their own determinations regarding eligibility. For purposes of my limited presentation today, I'll be focusing on Washington law. I'll briefly discuss state benefits, and then I'll turn it over to John Chirpak, the ULP Executive Director, who will discuss more of the federal pandemic enhancements for unemployment insurance benefits. Generally, let me back up a little bit to the previous slide. Okay. The Unemployment Law Project provides low-cost representation and free advice and counsel to people in Washington State who have been denied unemployment benefits or whose award of benefits has been challenged. ULP has offices in Seattle and Spokane. The Seattle office opened in 1984, and the Spokane office opened in 2005. In 2019, ULP represented claimants in more than 750 hearings. We also assist with filing petitions for review, and may represent claimants in higher state court appeal venues. Go ahead and move to the next slide, please. So a general overview of eligibility and how to apply in Washington State includes that a claimant must have a minimum of 680 hours of covered employment in a base year. Claimants can apply online or by phone. Benefits are paid generally a maximum of 26 weeks. And generally a claimant must be able to work, available for work, and actively seeking work. Currently, claimants are not expected to do their normal or the typical 3 searches for 3 jobs each week as they file their claims. And there's more information on filing claims if you visit the Washington State Employment Security Department. website or their Facebook page. You can get more information there. Next slide, please. There are 3 basic scenarios as far as job loss, and these include layoff. And a layoff is a scenario where there's no work available, perhaps the business closed. Generally, these claims for benefits are undisputed when a claimant will apply due to a layoff. Again, the layoff can also be temporary or permanent, so it depends on the situation. Next is a voluntary quit. In general, a claimant cannot collect unemployment benefits if he or she quits her job or his or her job. There are 11 good cause reasons enumerated in the statute where a claimant may be eligible for unemployment benefits. Those may include a medical quit, quitting for safety reasons, quitting for domestic violence reasons, or say, for instance, if a claimant's being stalked. They may also show good cause to quit if there's been a reduction of 25% or more in hours or pay. And these reasons are all outlined in the statute. The third scenario, the third scenario is termination or discharge. In these types of cases, a claimant may be eligible for unemployment unless an employer alleges misconduct. And misconduct, as outlined in the statute, can include excessive tardies or absences. Dishonesty may also include allegations of insubordination or violation of a reasonable known policy. And so these are typical cases that we represent claimants in frequently within the Spokane office, and also the Seattle office commonly represents in these cases. Although we have 2 offices, one in Spokane and one in Seattle, both of our offices represent throughout the entire state of Washington. And so the Spokane office may take a case on the western side of the state, and the Seattle office may take one in Whitman County or somewhere on the eastern side of the state. I think with that, I'll turn the presentation over to John Tierpak to present on the impact of COVID-19 federal changes in unemployment policy.
Thank you. I'd like to just add that the telephone hearings that a person may get is the reason why we can represent people anywhere in the state. And it's been quite an unusual time for us. Our office has had periods of being very busy due to periods of higher unemployment, but due to the COVID crisis, we've been getting many, many calls, and most of them are problems with access. People who are unable to file a claim, or people who filed a claim and are still waiting for it to be processed. And the law has changed radically because historically unemployment insurance only covered people who had what I call regular employment, a job with a paycheck that had taxes taken out, and they had to have 680 hours. So now with the PUA, pandemic unemployment, whole new categories are added. People who, like, for example, are independent contractors, Uber drivers, self-employed, and part-time workers with less than 680 hours are now covered in that program. Also, there's been an extension called PEUC added to the regular 26 weeks of 13 weeks added on. And that occurs occasionally during periods of high unemployment. And also, there's been additional benefits authorized. A regular unemployment claim may be anywhere from a low of, let's say, $100 to a high of $790 a week. Under the current law, an extra $600 is added, although the problem with this, well, a couple of problems. It's only currently through July. There's a move in Congress to uh, extend that, but that's being voted on right now, and it's a question of whether uh, both houses of Congress will pass it and whether the president would sign it. Um, One of the problems with this is that in order to qualify for the 600, you have to qualify for a basic claim, and this has been a problem for people who are now going back to work. So let's say the regular claim was would have been $400 a week, and they were getting the 600. Well, let's say they go back to work part-time and are making over 400. That would cut them off unemployment insurance entirely. I don't agree with that, but that's the way it's been set up. I was hoping they would calculate according to the total amount. So there's been big changes in the law. I'm hoping that some of these changes, like including people who are seen as independent contractors, will be continued to be covered in the future. Next slide. So one of the big things about unemployment is typically you have to be either searching for work or be in some kind of approved training program. Right now, there's a suspension of the job search rule of making the 3 job contacts a week. What has been problematic about this is that many people are telling us they're being cut off for not doing a job search. People are being sent questionnaires about their job search, and so this has been a problem for people with sort of inconsistent enforcement of the rules, and it's really hard to know what to tell people to do in terms of how to resolve it. People are being denied. I've been advising people to request hearings. Some people who are doing job search anyway, they are just submitting their job searches. So it's a very confusing time. And also during regular times, and now if you're in a full referral union, the kind of union that will find work for you, the requirement is to be in good standing with that union. The waiting week has been suspended. That is a issue where normally you'd have to wait a week to get your first benefit payment. That's been suspended so that you now should be eligible to get unemployment benefits the first week after your job ends. And then standby and shared work programs. This has been around, the standby issue has been around for a while. That is, if a person with a temporary layoff doesn't have to search for work, that's been used a lot recently. The shared work program is something in which the employer engages with the Employment Security Department to keep more workers on part-time while they receive a partial benefit. We've seen a lot of activity on that issue as well, and the coverage of that includes part-time workers. And prior to this, it had been only used for full-time workers. Next slide. So this is an eligibility checker, which is on the ESD website that persons can use to kind of go through to see what they may or may not be eligible for. And it's a helpful guide. There's a lot of information on the Employment Security website. I find it often hard to find and hard to understand the way it's presented, but it's a good start if you or someone you know is looking into applying for unemployment and is not sure you would be eligible. But of course, everyone is welcome to contact either our Spokane or our Seattle office for individual questions. We have a website, unemploymentlawproject.org, and you can send us an email as well with a question. Next slide. Okay. Thank you.
Thank you, John. I appreciate your insight in the changes to the unemployment insurance statutes. Again, my name is Therese Norton. I am an attorney with the Northwest Justice Project. So the Northwest Justice Project provides legal assistance and representation to eligible low-income families and individuals needing help with civil or non-criminal legal problems in Washington state. NJP operates the CLEAR hotline and has 18 field offices throughout the state. NJP also maintains WashingtonLawHelp.org. Washington Law Help is a public website which contains an extensive library of legal resources and self-help materials, including do-it-yourself court forms in areas of law needed most by low-income persons. And right here, you'll see a list of Know Your Rights topics that have specifically been developed in response to coronavirus and the current public health emergency that we are facing and all the legal issues that are coming up as a result of that. We encourage you to visit the website at www.washingtonlawhelp.org if you have any other civil legal needs in addition to unemployment insurance benefits questions. But NJP, given the unprecedented need that there is in the community for unemployment insurance benefits, NJP has joined the Unemployment Law Project in providing legal assistance in these matters. And so we are proud to be partners with Unemployment Law Project, who has many years experience with these cases, but given the level of need, we are adding to that resource for the community. As such, as Jen mentioned, I work in Bellingham, Whatcom County, and part of my job is to work with our Native communities. And I've been working with a number of clients who have also been faced with unemployment insurance benefit issues. In general, what I'm hearing from clients and our client community in our Whatcom and Skagit area are issues with coronavirus tax relief being denied or delayed. Other issues are the lack of connectivity that is available on tribal lands. That becomes an issue when individuals need to use the internet to access applications for unemployment insurance benefits or to even file their weekly claims. We also find that a number of clients do not have bank accounts, and so if they are trying to access unemployment insurance benefits quickly, then they don't get those benefits directly linked to a bank account, and so there's a delay in obtaining this critical financial assistance that people need right now. And in addition to the issues that we're hearing, similar to what some of the things that John Turpak discussed, some of my clients have said, for example, that they have been denied unemployment based on their response to a retirement question in the application process. We heard that thousands of people were denied unemployment because they incorrectly answered that one question and are still facing improper denial based on that one piece of information. I also hear from clients that they're receiving misleading and confusing correspondence from ESD. Like John Turpak mentioned, clients receiving requests for information about their job search. And when that in fact, that requirement has been suspended. we frequently work in partnership with the tribes in our service area, and the tribes are responding to some of these issues. For example, tribes are opening up computer labs so that people can apply online and file weekly claims. Tribal enrollment offices are helping tribal members get identity documentation. One of the issues you'll hear a little bit more about that we're hearing a lot of people encountering is the massive fraud that is going on now, and that ESD is now requiring that people prove their identity by providing documentation. And a number of our clients do not have easy access to their identity documentation, such as Social Security cards. And we hear also tribal governments dedicating tribal staff to assist tribal members in applying for and navigating the very confusing process that is unemployment insurance benefits. And today we are very honored to have Desiree Day from the Tulalip tribes here to talk about what she is doing in the Tulalip community. I'll pass it off to you, Desiree.
Thank you so much, Therese. Perfect. So my name is Desiree Day. I'm the HR director here for the government. I've been employed here for over 20 years. I've worked a majority of my career in the human resources field, from training to employment to human resources investigations and different things. Currently, my assignment is to help tribal members, especially our tribal employment workforce, and fishermen with their unemployment. So this has been kind of new territory for me. Other than responding as an employer, we've really dug in to help. But I'm just going to go over some information with the Tulalip tribe. I also want to thank Natasha Gobin for the beautiful blessing. It is something we do here often. We always open with a prayer and a blessing. It does help just keep us focused, and it's very respectful. So thank you so much, Natasha, and thank you so much, Jennifer Yogi, for inviting Tulalip tribes to this. And I'm very honored to be a panelist, and I'm super excited to share what we're doing here at Tulalip. So a little bit about the Tulalip tribe. Tulalip is a federally recognized Indian tribe. We're located on the Tulalip Reservation, right here in Puget Sound. We have over about 22,000 acres of reservation land, 50% of it which is in federal trust. We're also, we've been established since the Treaty of Point Elliott, which was in 1855. It is also a document that was at our museum here. You could actually view the actual Point Elliott Treaty, which was actually here in Tulalip. So it was a very awesome moment for us to be able to have that here. Of course, COVID hit, a little different. Of course, we have over 4,900 tribal members and counting. We're a very prosperous tribe, and we're very excited. So next slide. This is our mission and vision and values. I thought it was important because I think Tulalip is honoring that. Our mission is together we create a healthy and culturally vibrant community. And our vision is we gathered at Tulalip are one people. We govern ourselves, and we will arrive at a time when each and every person has become most capable. And I really say that because we reach out, we try to engage with our employees and our membership so that we can be most capable. Next slide. This is just an area map. I kind of wanted to talk, because I talked about the 22,000 acres. It just is a great overview of our area. So that was something I wanted to share. Next slide. And this is, so I just kind of want to go into a little bit about what we're doing here at Tulalip to serve our tribal members and current employees, even those that are furloughed. We have dedicated staff. It's not just myself. There's an HR manager, and there's also our executive director that is jumping in and really learning everything about unemployment. I wanted to speak to the unemployment benefits fraud because it's been our primary thing that's really shook up a lot of our employees, and a lot of people are not being paid because they have to verify their identities. So what we've done in order to help our staff is we've opened up our computer labs. We've dedicated staff, so such as myself, I can make appointments with people. They'll sit there. It's so much easier for me to guide them through the unemployment process if I get to see that. So we do have a lab here. They come in, they set an appointment, and we have them bring all their documents because we have all the equipment to be able to upload and scan. So with regarding to benefits of fraud, it's been our biggest issue because it's made it very, very difficult to talk to anybody at unemployment. Prior to the big ESD breach, as far as fraud, we were able to contact unemployment. It was very, very miserable. It would take us sometimes 3 and 4 hours, upwards of 6 hours of holding before we even got to talk to somebody. And it is nice to have somebody on the line because a lot of claimants, this is their first time ever claiming. So they don't know what they're doing. They don't know what to say. And so because I've helped with so many different claims and spoken to unemployment almost every day for a month, I got to know a lot about what the issues were. So I wanted to include this because this has been something our organization was hit a little bit. We had a couple of fraud, including myself. So I had to follow these steps, and I just think it's important we talk about it. Next slide. And then, of course, the resources page. But if I can talk a little bit more about some of our challenges, if you guys don't mind, if I just talk a little bit about what we're doing. So a lot of our challenges were what previous panelists had talked about, the one question regarding retirement. There were so many of our employees that we had to call in. And at that time, ESD was allowing the agents over the phone to do the change, so they didn't have to appeal it. Now we're to a point where I think ESD will actually hang up on you if they don't like what you're saying, or if they don't have time to help you, or they'll give you a more vague answer like, you'll just have to keep pending, or we got your information, thank you. Before, the agents that I was working with would actually adjudicate their claims over the phone, and then they would just say, okay, we're going to restart your claim. Since all that fraud is hit, I think they're a little bit more cautious. So it's been challenging, very, very challenging. And with the fishermen, we make appointments, we open up our lab, we go through the process. It's been taking upwards of an hour now for our PUA claims because of all that fraud. There is a lot more questions that they're asking now. And I don't know if you guys want to take some questions or if you guys want me to just start chatting a little bit about some of our challenges, but that was one of our challenges, is that the PUA claims have altered. Also, John spoke to the standby issue. It is also something I get a daily phone call about. Those are auto-generated letters from Employment Security Department. So it hasn't more or less caught up to their new rules. And so a lot of our employees will call us as soon as a letter comes through that says you're required to look for a job. Even if I go on the back end, because we have access for unemployment responses, even if I were to request just for that employee to be on standby, it actually has a pop-up box that says, do not do this because it's not relevant. But those letters do cause a source of anxiety for a lot of employees because it seems like we're lying to them. We're telling them disregard the letter, but the letter says look for a job. I can tell you I've helped someone this Tuesday when we filed a weekly claim, and they've actually removed the question. So they're not even asking your job search. Did you complete a job search? The only thing I don't know about is whether or not they're doing it for PUA. PUA is a little bit different, and I think it does require one job search requirement, so I'm not sure about that one. But I've been telling all of our employees that standby is irrelevant. No one in Washington is required to look for a job. And now unemployment has removed the question. So I just wish they would stop with the letters. But let's see what else. I did want to say that we did make contact with unemployment, and in speaking with an agent regarding all of the fraud. If you have an employee who's been impacted and you've uploaded your identity or faxed it in, it's being resolved. If you mailed it in, you may want to fax or upload it. I advise every one of my claimants to do everything over e-services because it's so much quicker. And if you get in contact with unemployment, you can actually have them check your mail, and then all of your evidence is right there that you've uploaded. So those are a little bit about what we're doing, how we're trying to triage the situation with Employment Security Department. It's been more difficult with all the fraud, but I wanted to say that one of the agents said the FBI was really handling it. They were in there investigating everything. So hopefully people will start being able to get paid, because we have employees who haven't been paid for 2 weeks just simply because they're waiting out the FBI to complete their investigation and verifying their identity. So far, nobody that I've worked with has, for 2 weeks, they verified their identity about 2 weeks ago, and they haven't been paid yet. So it's a little discouraging, and I'm hoping just the Memorial Day weekend kind of caused delays in payment. But today was a payment day for unemployment, and so far, no one's really been paid. So those are things that we're monitoring. I think that's all I have to share, unless you guys have any questions. So I'm going to go ahead and turn it back over to Jennifer.
Thank you so much, Desiree. And actually, there were a couple follow-up questions that maybe we could start with, because they have to do with fraud. The first one is, how do you know if someone used your name? How do you know if you've been the victim of fraud? What, would you get some kind of notice, or how would you learn that you were the victim of fraud? And I don't know if you know the answer to that. If you do, go right ahead, or the other panelists can jump in if they have experience in addressing that.
I just wanted to add how we're identifying it here. As an employer, we get a benefit summary. So it lists all of our employees who are actively collecting unemployment. So there were a couple people on our list, like myself and other people who have been working full time. So we're like, you shouldn't be on the list. And so we've actually approached the employees, told them that they're there, and then told them to report the fraud. We've also had some employees who receive just a random letter. And that's how I was discovered, is I get sent a letter just saying that my SEEP I was eligible for SEEP, but it was very panicking. But when I was one of the first people to get the letter, so it was terrifying. And some people have gotten it where they owe, $8,000.
I've also heard some things that might be helpful. The idea of being notified. So everyone on unemployment always gets all kinds of notices during normal times anyway, questionnaires, things like that. So a number of people have been notified that way. I saw a news report about a doctor who is working full-time currently and just received a notice from the unemployment office by mail about asking her about her job search. So that was what alerted her. And then another thing I've heard that I'm not sure if this is the best thing to do, but I've heard that some people have gone to the unemployment site and opened up their own account. Not that they're going to make a claim, but to open an account. And if they put in their information and they're being told, you're already been, you already have an account, and you don't. So if I went in, put my name and my identifying information in, and I'm being told I already have an account, that would be a clue that there might be a problem there because of that.
Thanks, John. And then I would also just, we can share some of the slides from the presentation today. One of the slides addresses what to do, some next steps to take if you have been the victim of unemployment benefits fraud. So that kind of gives you some good resources. Thanks, Therese. We had another question that I think is coming up for a lot of people, which is, how does the Employment Security Department deal with different sources of income? So if somebody works maybe part-time as an accountant for a tribal agency, and then has part-time work as a fisherman, how does unemployment security treat that person's income for purposes of calculating their benefits?
Well, I'll take that one. So what they should be doing is combining the wages. So the unemployment office looks at a person as an individual. When I started doing this work, I always thought it was just based on one employer, and that the claim was based on just, one job separation, one employer. So they look at everything you've done in the last year or year and a half, and combine those wages and hours to come up with the regular benefit amount, which would be anywhere from, $100 to $790. And under the current rules, if it doesn't reach the 680 hours in that base year looking back, then that person would be eligible for the pandemic unemployment for the people with less than 680 hours and the independent contractors and self-employed. It gets complicated when people have a mix of self-employment and of regular employment, that they should be looking at everything. And some people have concerns that hours are not properly reported by employers. You could give them that information to update it. But some people I've talked to have sort of given up on that and just moved right into the pandemic unemployment and have been happy with that. So that may lead to some questions in the future, um, but that may lead to some questions in the future about what claim they should have been eligible for. But right now, people need the money, and I just encourage people to provide correct information. I think that's one thing about unemployment. Even before this crisis, there's always problems with claims, mix-ups, errors, people being denied for various reasons, people being told they shouldn't have established a new claim because they had an old claim or so. Just all these complicated things. But people are in good shape if they're providing accurate information. And if there are problems in the future, we've done a lot of hearings about resolving those overpayment issues.
I just wanted to ask you, John, if you had any guidance for them seeking PUA that need verification of income. So that was something that we had with our fishermen, and so we dedicated our natural resources staff to help with fish income statements, and so that's what we upload for our fishermen. But I see we have some people who are asking questions as independent contractors, and I didn't know if you had any answers as far as what proof of income they would need to upload, because there's a part in the PUA claim where you have to upload your proof.
I've been talking to people who said that they've been asked for and submitted things like, let's say, a tax return for the previous year, quarterly income statements, depending on the individual situation. What I've learned a lot in the last few months is that people are in very, very different situations. A person who may call themselves, self-employed may actually have a business with many expenses and a complicated financial situation and a lot of records, whereas other self-employed people deal a lot in cash. They might provide an individual service. They might do, I've talked to people who do things like landscaping, yard work. A lot of it's in cash, and there's very little in their expenses, and often the documentation is harder to put together. So I would just encourage people to put together whatever they can. They can make a declaration, like if they are lacking certain documentation, they can do like a sworn written statement trying to summarize what the income was in the past. That's one thing, but it is a whole new issue for unemployment. And I've heard mixed things back in terms of people who've had claims go through and claims not go through. But I always want to emphasize at the end of what I say is that, if you report accurately, you're in good shape. And if you are denied, read the denial letter carefully, because there should be instructions on how to file for a hearing. And that's where we would come in, Unemployment Law Project, because I've done hearings in the past where, let's say, someone didn't have enough hours for an unemployment claim, and at the hearing they were able to provide testimony and other documentation that a judge could then verify that they are eligible. Julie, I don't know if you have anything more to add about that issue.
No, I don't really have anything to add to that. Thanks, John.
Okay. All right, thanks.
We had another question that I don't know if this is something you've dealt with, Julie, but if a person works in Idaho and Washington, they're laid off in Washington but still work in Idaho, can they file a claim for lost wages in Washington? It's not clear if, I'm not sure if the employer is located in Idaho or Washington from the question.
I think that, and John, maybe you're probably better suited to answer this question. I know that at times I have had some calls regarding this, but I'm not sure. I think John would probably be better suited to answer this question.
It's a tough question. I'm going to try to sort it out with two different aspects of it. One is what hours count toward the unemployment. So normally, if a person works in 2 states or more, that we've talked to people with even more than that, but multiple states, and they open up an unemployment claim, the state they file in should contact the other states to get those hours and wages to kind of see what the claim would be, because there's interstate reciprocity. Okay, so that's in terms of establishing the amount. But then the question of, are they eligible for benefits, I think comes down to kind of working through this on as we do on a case-by-case basis, is if they're still working, they of course should keep working, but then if they open up an unemployment claim, they're asked every week, did you work this week? And if the answer is yes, then they're asked, how much did you earn in that week? So let's say somebody were to open up that Washington claim and they're still working in Idaho. And then their Washington claim, based on all the information, is $300 a week, potentially $300 a week. But when they're asked what their income is on a weekly basis, and let's say they're making $400 a week from their part-time Idaho job, they would not qualify then for a Washington claim, nor qualify those for 600. But if the part-time work is less than that amount, then they would apply. Then they would qualify for a partial Washington claim that would allow them to get that extra 600. It's very complicated, and this stuff gives me a headache when I go through it like this. But that's what we're finding. So it's an individual thing. Now, people always ask, well, should I apply? How do I know if I'm going to be eligible? Yes, you can go to the ESD website and look at some charts and try to figure that out. But if you file and you provide correct information, you may be denied for different reasons. Maybe why the job ended could be a reason why you're denied, or you could be denied because you have more income from the current job that would make you not qualified. But it's not something to worry about in terms of applying, because if you're providing accurate information to the best of your ability, that gets sorted out. Because, for example, if I have a full-time job now, I could apply for unemployment. I could report my income, and then I would get a notice saying back that you make too much money and you don't qualify for a claim. But there's nothing wrong with that. Obviously, in my case, it would be a waste of time. But when people are in doubt, applying is okay to do, because it's really hard to answer things very specifically without very specific information.
Sure. Thanks, John. We've got a couple questions related to unemployment and disability. One question is, if a person has a debilitating health condition or is a vulnerable part of a vulnerable population and they quit, can they get unemployment benefits? And a related question is, can a person receive unemployment benefits if they also receive state disability benefits? Not sure which kind.
With regard to the question about a debilitating health condition, generally, again, you can't get unemployment benefits if you quit. However, quitting because of illness or disability can be an exception to that. you have to quit because of the health condition. You have to um, before quitting, you have to try to exhaust all your remedies, maybe ask for an accommodation. You know, if you attempt all of that and it's futile, you may be able to be eligible for benefits. But again, one of the criteria to be eligible for benefits are you have to be able to work. And so that becomes a sticky point for individuals in that situation. John, I don't know if you have anything to add to that.
Well, yes, and this is something I always remember. There's a case, and I can't find the case, but Ken Yusserlis did a case about whether people receiving Social Security disability could get unemployment at the same time, and the court ruled yes. And the reason is that the definition of disability can be different. That is, a person may get a benefit program like Social Security that finds that they're eligible for that benefit program due to their disability because they're not able to engage in substantial work activity, you know, to support themselves. But often a person receiving Social Security disability may get a part-time job that fits within their medical limitations. And if they are laid off from that job or lose that job through some qualifying reason, they should be able to get unemployment as long as they're able to take suitable work within their limitations. And this is a very difficult issue. We've seen cases like this over the years where someone at the unemployment office finds out that a person has a disability program and will just rule immediately that they can't work. And then at a hearing, we are able to show that they can do some work based on their limitations, their abilities to work, whether it be part-time or having certain restrictions. So it's a complicated issue. I try to give a long answer here to try to flesh it out, but it's not a simple yes or no.
And I'd like to add just a couple more thoughts to consider. Whether someone receives unemployment insurance benefits as well as a state disability benefit might also be impacted by whether eligibility for the state disability benefits is a condition of that is that you are not able to work. So if the type of state disability benefit was such that in order to be eligible, you wouldn't be able to work, then that would present an issue with simultaneously being eligible for unemployment insurance benefits. Another factor to consider kind of builds on John Turpak's point about the definition of disability. Disabling conditions can change over time, and so it's important that if someone is facing this kind of a situation, to seek out legal representation, because that would give an individual a chance to explore the nuances of what your particular situation is, such as things like whether at a particular time you met a certain definition of disability. So I definitely encourage you to seek additional legal assistance in this case.
Also, I would like to add something else to that. I had a recent conversation about SSI versus SSDI, and what came out in the discussion with the SSI attorney is that if a person, let's say on SSI, which is supplemental security income, which is a federal disability program, the problem there might be if they get income from unemployment that's high, you know, they get income $600 plus whatever their weekly amount is, that might economically throw them off that program, you know, that's excess income and resources. And the state disability programs, if you're talking about ABD, or if there's other programs where income is one of the criteria, it's not only having a disability that qualifies, but having low income or no income or assets. So unemployment could throw that off. And the concern that came out of this conversation with this other attorney and a community advocate was for people to be aware that sometimes if you lose your uh, benefit program, you may be losing your medical coverage as well. And that could be, for some people, an absolute disaster. So it may not be worth it to even go for unemployment. And these are very individual cases, very individual situations. Because what I've been told is that if you lose a program like SSI, getting back onto it later on may be very difficult.
Yeah, good point. So if someone wants to know, at what point do they ask for a hearing? My claim has been pending since April 5th. No one has asked me for any information to move forward. Is that unusual? Is that we just need to wait? Or is that at that point, if someone's claim has been pending for almost 2 months and no action, should they ask for a hearing?
I just wanted to kind of add content to that because I've had a couple that I've actually, in order to really understand what their SAW count looks like, I have them come here so I can look at their screen and see that. And I've seen some people, like I just met with somebody today and she's been pending for 6 weeks and it didn't give her an option to appeal. So I didn't know if they're just verifying information from a previous employer. We did send them an e-services like message, but she said when she called them, they told her, we have all your information. Thank you. You're just pending, but it's been 6 weeks. So I'd love to know the answer to that because some people, they don't have the option to appeal and some people do have the option to appeal their decision. Some are just pending. And so I had one employee who did have it and it was an initial question. So if you don't respond to those earlier letters, that can just kick you out of disqualification. So all of those were disqualified and there was only one option to appeal for that person and it was her original question. So as your weekly, they tell you to file every week. Well, then you're getting denied and weird letters come out. So with that question, I'd love to know because, you know, should my employees be calling in every day to ESB to say, hey, where am I at? But those who have and have taken the time and hours on hold, have literally been told you're just pending. So it's been a difficult process.
This issue has been ongoing. I speak with claimants every day who have claims pending 6 weeks or longer. Generally, it's about 6 weeks, but many initially were not offered the option to appeal, and they should have been. I encourage them to try to send the messages through their SAW account or try to call ESD. Of course, that's a whole other issue, and they can rarely get through. You know, they get through and they get hung up on. But my understanding is now ESD is supposed to be, and they have been for several weeks now, they're supposed to be working 6 days a week and return calls on Sunday. Obviously, they were on hold for a couple days when the fraud issues broke. But I don't know, I don't really have any other answers. I just know that this is a very common scenario that claimants, and I just had a call this morning with that scenario. Claimants have their portal just says that their benefits are pending or they're in arbitration, which is supposed to take maybe 21 days, but that's taking longer. So, I mean, things are not, you know, things are not following any sort of specified timeline. I don't really have any advice except, again, to call ESD, to try to call ESD or to send messages through the portal. John, do you have other suggestions?
Yes, I do. And I'd like to just share a few scenarios I've been hearing. Again, we've been getting calls for months on this, so I've talked to many people. sometimes when a person's in this pending status, if they find the address of where to file for an appeal, uh, there's a post office box in Olympia and a fax number. Sometimes when they send it in, they will get like a rejection letter saying you can't appeal because you haven't been denied yet, even though they've been waiting for weeks and weeks. Okay. But other people have said that when they submitted their appeal letter, things got fixed. And so it makes me wonder if maybe somebody who might read these appeal letters might be able just to go in and fix something if it's just a technical thing, not a real something that really needs to have a hearing with the judge. Okay. And then other people have said that they have gotten hearings scheduled based on that, even though they were not formally replied. So I've heard for all three. So what I get from this is there's no harm in requesting a hearing. There's a post office box in Olympia and a fax number. Another thing I've been suggesting, and I began to suggest it a lot more recently because of some response from people, is to contact your state senator and your state representatives. You can go to the Washington State Legislature website, which is leg.wa.org. And on the homepage, you can find your district. You put in your address and you see who your state senator is and your two state representatives. Then you can find their email and their phone number. I would suggest contacting all three, both by phone and email. And in some cases, it works. And it may depend on whether a specific representative has a person on their staff who's very active and enthusiastic about their job and will try to advocate for them. And I've heard some positive results there. So that's worth a try. It concerns me if it's just sitting there because we don't know whether it's just waiting in line or whether it's sort of fallen by the wayside on a computer. And electronically, I know what computers are and how they work, but I still have a visual of a person working in an office and hundreds of files being piled up, and sometimes if someone's working in an office and there more files keep coming, the ones might get put, on the side, on the floor next to the desk, and then they get moved, to the corner of the office, and then they get moved to the storeroom, like if you imagine like files just coming in and coming in. So it concerns me because if I'm talking to somebody who filed 9 weeks ago, I would assume that if they're taking things in like a chronological order, like, first in line, next in line, next in line, that person should have been at least served a few weeks ago, because then I'm hearing about people who have filed more recently who've had their claims approved. And whether that's high-speed internet and the difference between the class and the economic situation and access and the terrible disparity in the communities across our state, that could be a factor. Or there could be another hitch or some glitch or something with that application. So it's really hard to say. And it's been very frustrating for our office to take these calls when in past years, let's say last year, if somebody had sort of an unusual problem, let's say they filed for benefits and didn't hear anything for weeks, or if they won their hearing and they weren't getting the money, some oddity like that would come up, we could contact somebody at the state. And now that's not working so well. So it really puts us in a bad spot. But I encourage people to keep going and not to give up.
On that same line, I spoke with someone yesterday who said they they got a note in their SAW portal that said they were disqualified, and so they quit filing. So we always encourage everyone to keep filing, because if things get turned around, which they hopefully will, then they will get all those benefits. But if you get something that says you're denied or you're disqualified, just keep filing each week, so that if things do get turned around, you get those back benefits.
Thanks, Julie. We've got a couple of questions relating to when somebody has to go back to work. So these scenarios are similar. The first person says, what if say I'm over 65 and I have an underlying condition? I'm afraid to go back to work because I'm worried about getting infected. Is that person eligible for benefits? The second person says, the employer has asked me to come back to work, but I have provided direct care for a high-risk person, and I have a doctor note excusing me from work because of that care that I provide. According to the unemployment insurance website, I'm not sure if that's ESD or ULP, that's an example of just cause. So how can I get the employer to extend the my layoff, yes.
Well, if they are claiming now, they have a claim open, and it's a matter of keeping claiming. Don't go back to work into any dangerous situation. That's clear. I've had trouble in the last months giving answers sometimes when the answer is not clear, but this is very clear. That if you're at risk or family members at risk, do not go back into work. But communicating with the employer is good to let them know that you're not quitting and that you will return at a later time when it's safe. And getting the doctor's notes or other documentation can be very helpful in a case like that. But then if the employers insist on keep offering you, when you claim in the weekly claim, they will ask you, did you refuse any offers of work this week? I forget the exact wording, but it's a question to that effect. Did you refuse work? The person should say yes, and then provide accurate information for the medical reason and safety reason why they did not accept that the job that's unsuitable. And that should be fine. If there's a disagreement about that, or if they're denied because of that, they can request a hearing and then call us for help at the Unemployment Law Project. But I think that one of the problems out there, and I saw this early on, is that just because a business is reopening or just because a job is considered essential, it doesn't make it safe for certain individuals. And I think it goes back to that idea about suitable work. People must be able to accept suitable work. But, a 30-year-old person who's healthy and has no risk factors, who's going to go back into a work environment with proper safety precautions, that may be good for them. But, a family with immunity issues, or other health issues, or a person over 65 with respiratory issues, that same job, even with safety precautions, may be a high risk, and so I think that no one should put themselves at risk or their family members at risk. There are individual choices to be made. I've talked to people who made some choices that I don't agree with, but that I wouldn't do myself. But people make those individual choices. But I think that the employers will vary. There are some employers, people have gotten back to me, that when the person provided them either medical information or an explanation, the employer just said, well, take care of yourself and just please let me know when you're ready to come back. That's the kind of employer I would want to work for. But other employers are giving ultimatums that if you don't arrive Monday at 9 o'clock, your job is done. And if you're terminated from a job under those circumstances, I would argue that's not misconduct, and that you should be able to get unemployment if the employer fires you over over not coming in for medical reasons, because it's a long-standing issue with unemployment cases we've done over years that if you're absent from work due to medical issues, legitimate serious medical issues, that is not misconduct and you should get benefits. Um, uh, this has been a common question, and it shows how serious this is out there and how many difficult choices are being made right now.
Okay, the next question has to do with somebody who's a Canadian citizen, but has the right to live and work in the United States under the Jay Treaty, which you may not be familiar with, but it allows people who are 50% or more Aboriginal First Nations from Canada to live and work in the United States without requiring them to become citizens. And so the question is, if that person was working here in the United States, lost their job and had to return to Canada, are they eligible for unemployment benefits?
I don't know the answer to that question.
I'll take that one just because I had a recent case of a person who was physically located outside of the U.S. Due to the COVID situation, and the claim was successful. So on the issue of eligibility, if they have, the hours worked here and a qualifying separation and they're legally able to work here, they should qualify. We've had calls from people from Marshall Islands and other countries with immigration status that's not as clear as some, let's say, like people from the Marshall Islands have immigration status that allows them to work in the U.S. due to rules, complicated rules I don't really understand, but just to say that they're part of a U.S. territory or a U.S. agreement that they can work. And so, yes, the person should be eligible for benefits if they have enough hours. If they don't have enough hours, they may be eligible. They should apply for the pandemic. The question of where you're located when you have your claim, the law had always talked about that you have to be physically present on U.S. soil to be eligible for unemployment, with the idea that you have to be readily able to start work. And that's been the law for years. And recently there's been some movement on this. There was a commissioner decision, a court case a few years ago, where a person who was filing, who wasn't physically present in the U.S., the court found that he was able to get unemployment because of the nature of his job and the nature of his ability to freely move to accept work. And a case I had recently was very interesting. It was a flight attendant who's based in Washington State, but she was laid off from her work being a flight attendant. And when she took the layoff, or she was with her family in Singapore, and she was initially denied unemployment because she was told that she wasn't physically able to work, she wasn't available. And at the hearing, that was reversed, that the judge found that based on that other case law, by the way, but also that when her layoff ends, she is able to get on a plane, within a day's notice and resume work. So she is readily available to work, even though she's in a foreign country. So I think all those principles should apply here, that being physically present in Canada should not be a barrier to getting unemployment benefits. This is kind of a long answer, but I think that it's something to consider, you know, hearing about this treaty and knowing that there's a lot of cross-border employment. This may be an issue that we see more in the future. I would encourage anyone who is denied based on this to request a hearing and encourage them to contact our office for help.
Great. The next question has to do with the expanded benefits. If a person is only eligible under the expanded benefits, how far back in time can they seek the benefits for? Is it only through from the date of application, or can they seek benefits from the time periods starting of when their hours were reduced or ended?
Well,
Oh,
I can take a stab at that.
want to go?
Yeah, and please, John, add on to whatever I say. My understanding is that backdating a claim is allowed, and that good cause, the good cause factor that usually applies for allowing you to backdate your claim does include the conditions that we are currently facing under the COVID-19. Closures of businesses and people being laid off. John, do you have anything else to add to that?
That's it. One of the first things they announced when the crisis hit in March was that they would be more flexible with applications, because even back then they knew that it would take a long time to get people processed. And so they should be flexible. If they're not, again, I keep repeating, read your notice carefully. If you're denied for certain weeks, file for a hearing.
I just wanted to add only because when we've been working with our fishermen, it has allowed them to back claim to, I think it's February 3rd is the first claim period that you could have done with PUA. So on some of our initial applicants that came in, we successfully went through, we filed, it was great, they got their money right away, and then the fraud hit. So now a lot of our fishermen, it's taking a lot more time, and it does ask you why it's taking you so long. So a lot of ours, they just didn't even know that they were eligible or didn't have a computer at home to apply, but it is something, if you're trying to back claim, they do want to know why you're trying to do it now. So that is a little bit different. And I wanted to share that because as we're helping, the format has even changed. And they actually want you to upload documentation on why you haven't done it. Also for PUA recipients, they do have a requirement to do one job search log. And a lot of our fishermen, originally who went in and did it, they have to list a job search requirement, which is a little odd because it's so new and a lot of people weren't doing it. But a lot of these people were really actively looking for work, so they had some things to pull from. Like a lot of them typically came to the tribe. When they weren't able to fish, then they wanted to come here and work. And then, of course, we were closed and different things, but they did try to seek employment this way. So that's what some of our fishermen have noted. Although I don't know, because I worked with fishermen last week when we filed. I don't know if his has been approved yet. And I'm just seeing that backdating may have issues. So I wanted to say that was amazing, because working with unemployed clients, most of them are not allowed to claim except for that last week that you didn't work. So I've had people who are waiting to collect unemployment. I don't know why. But when they were like, I've been unemployed since April, if you're doing a regular UI claim, it's not going to let you backdate. It'll only let you backdate for the last Sunday, basically. And so a lot of my employees actually really were upset about it because they had taken so long. A lot of it is just, it's very, it's intimidating. The Employment Security Department, it seems very easy. Some people get through it, it's perfect. And then I've told some people, you've done everything perfect. There isn't anything you did wrong. It's just employment security. The website's horrible. And sometimes weird little, because they upgraded, there's weird little kinks in there. And so even if you call in, the unemployment agent will go, well, there's nothing wrong with your claim. But it was some hiccup or some little error. And so most of the agents were able to go in and resolve some of those things behind the scenes. But you are able to pack claim. I thought that was very interesting with PUA, given that unemployment claimants aren't allowed to do that. So I just wanted to share some of our stories.
One thing I'd like to add about a job search is I've had this question come up a lot from somebody who's being asked to do a job search, and they say, well, why should I even apply if no one's hiring right now? Well, I would say, just like during regular times of employment, when I talk to somebody whose field is that their particular field is not hiring, a job search is a job search. It's a job contact. It doesn't mean you will get the job, or even if there is a job. So doing something like sending somebody your resume, or filling out their application online, or even contacting them to talk to them and apply, maybe if that's customary in the field, that should count as a job contact, a job search. It's something that you're doing affirmatively to make a contact with a potential employer. And even if they're not hiring, if it's in your field, then that's work you're qualified to do. That should count. And I think that some people have been afraid to do that because they feel that somehow that there's something wrong with it, that if you know that the place isn't hiring at the moment, that somehow that shouldn't count. But it does count, and a person shouldn't be denied unemployment just because economic conditions are bad in a certain area of work. I mean, that's why we have the whole system to help people in that. But by making those contacts, it may lead to something in the future, and that may be good. So so there is time. If you're unemployed, there is time to do this, and it's probably better, if they're asking you to do it, to just go ahead and do it, because anything you do to kind of cause them to question your claim is going to slow things up.
Thanks, John. And Desiree. So somebody clarified a previously asked question. If they are out on FMLA during the business's closure, and then the person is called back, but has documentation from medical providers saying it's not recommended, so the person then quits, are they eligible for unemployment benefits? And maybe you kind of answered that earlier, in making it clear that you're not saying you're not quitting, that you're going to come back when it's safe. And I don't know if you're out on FMLA leave, if that's a different twist to the question.
Well, all these cases are very complicated. I think that if the person has already quit, I would recommend they file for unemployment and explain why they quit, and to emphasize that it was medically necessary to quit. That would be, I think, the best way to go. If they haven't quit, or that they still have that relationship, I would urge what I said before, which is to contact the employer and just basically, whether formally or informally, ask for an extended leave and then file for unemployment. If they are able to do some kind of work, and this is where it gets a little bit tricky, because you might not be able to work at that particular job, but in theory, maybe you've recovered to a point that you can do another job under certain safe conditions. Can you telecommute? Can you, there are so many different jobs, so many different possibilities. It gets on to be like individual circumstances. I've talked to people who, when they told their employer that they could not come in for medical reasons, the employer offered them working from home, and that worked out fine. There's other cases as well. So it's important, I think, to if you are not able to do, if the person is not able to do any kind of work at all, if the disability level is so great that they can't do anything, even if it's telecommuting or anything like that, then they might want to look into other disability or long-term benefits like Social Security rather than unemployment. But each case is very different.
Yeah. One of our participants says that she was approved to be on standby but received notice to look for a job. Do I still search?
I'll take that question only because it's one of our most common questions that we ask our employees, and I've been advising them that it is not necessary. And I was a little hopeful this week when I did watch someone do their weekly claim, because it is also something that we offer our employees that are having difficulties with technology, or just, you know, clicking the wrong button is a very big deal with ESD and e-services. So if you click the wrong question and answer, it's 100 times more difficult to troubleshoot what you did than for me to just watch you and make sure that there's two sets of eyes making sure the weekly claim goes in. So when I watched someone do their weekly claim, I did notice, and I actually took a picture of it because I was so intrigued, that they removed the question. So if this person, I would say I wouldn't worry about that. It is also as an employer, when I go in and I want to say, hey, XYZ employee needs to be on standby, it actually pops up this huge warning label. It's all red, and it'll say, this is not necessary, because no one has to search for work right now. So I was happy. I wish ESD would stop sending out those auto-generated letters because they cause so much anxiety for everybody. But I would advise the person that you do not need to look for work. And then when you do file your weekly claim next Sunday or Monday, you might want to pay attention, because it won't even ask you the question.
I think we have time for one last, it's sort of a comment, but I guess it also raises a question. Someone says this, that I wish Idaho had something similar, as we have businesses in both states. And I don't know if any of our panelists know if something like Unemployment Law Project or similar webinars exist in Idaho. If not, and we learn of something, we can share it out later.
Okay. On our website, on the Unemployment Law Project website, we have a referral list that some law students have worked on, and it will list state by state what kind of legal aid office is doing unemployment in that state, and I think Andy put that up on in the chat, I believe. So
Yes.
Idaho Legal Aid, they I'm sure are very busy because they're doing all kinds of legal issues, but I would recommend contacting Idaho Legal Aid.
Don, I think the last time I checked, although Idaho Legal Aid does work with, I think it's the Coeur d'Alene tribe and the Nez Perce tribe, maybe other tribes throughout Idaho. I don't believe, just from their website, that they do work on any unemployment benefits cases.
Well, there's an opportunity there for a new project in Idaho that we would be happy to advise and support.
Great. I think we're going to be wrapping up here. Can we move to the next slide with contact information? If people have individual questions or need help with unemployment benefit claims, these are some resources. We are also thinking about having future webinars. So if that's something that's of interest to you, please let us know in the chat box, and also let us know if there are specific topics that you would like us to address for future webinars for unemployment benefits for the Native community. Any other final comments before we close?
I just want to say thank you to everybody and all of the participants for asking questions. And of course, the Leah Tribes would be more than willing to partner with you guys again if you guys host another webinar. I think this was very educational for us as well. And I took notes the entire time for myself. So.
Thank you so much,
Thank you,
Desiree.
everyone.
Desiree, thank you, everyone.
Thank
Thank
you.
you.
Thank you, guys.